Chair. I'm just putting my timer on so that I'm conscious of the time. Good afternoon to you, Chair and Commissioners. May I say that I don't intend to be as long as 1 hour. I think it will depend on the level of engagement between the Commissioners and myself as to whether we will need 1 hour. And can I say the reason I'm not going to need 1 hour is because the Commission has itself now conceded that a postponement is appropriate. The Commission has chosen a date of 14 August 2026, and that means the postponement application which has been brought by my client in respect of his evidence for the 15th of July rolled over to the 17th of July, rolled over to the 24th of July, is effectively unopposed.
Yeah, but the crucial issue is that the effect of what we have before us would be that Mr. Karim never ever testifies. So that's a serious issue that needs to be dealt with.
I'm not sure I agree with that characterization, Chair, but I accept the point that you make that the postponement as to whether or not it's by a postponement to a fixed date as opposed to a postponement not to a fixed date but subject to some...
But with what we have before us, the doctor's report, the effect as we sit here now is that even on a later date to which we may postpone, we will be told the same thing.
Indeed, sir.
So ultimately, the effect will exactly be what I'm saying, which is that Mr. Karim will never ever testify.
Well, I don't know if I agree with the characterization that you'll necessarily be told the same thing, because what you'll remember from the treating doctor's report to you, and again, I'm not going to go into the specifics of that in light of the ruling on the in-camera issue, but what the treating doctor says is that the position of my client is dynamic and it is subject to change. And that's why one of the things that the treating doctor himself proposes is to account to the Commission under oath once every 2 weeks to update the Commission regarding the client's position and whether he can or cannot testify. It's also why the doctor's evidence under oath is to suggest that there are alternative means that can be explored.
Continue.
No.
I wanted to say, based on what we have, an educated guess would lead one to say, even though you've just made the submission that you've made, we can't hold our breath.
No, fair enough. But I was responding to the characterization that you'll necessarily be told the same thing in future. It was simply to say that that's not entirely correct.
I guess
you may be told the same thing in future, but you may not be as well.
I guess I'm saying exactly the same thing I said earlier when I say we can't really hold our breath.
No, indeed so. Yes. Indeed so.
Can I also just check your characterization of where and how we got here? You say the application for the postponement is not opposed. I don't see that is correct, a correct proposition. You're asking for a postponement to an indefinite date, which is completely subject to what the treating medical person is going to determine whether he ever comes back and on what date he comes back. But more importantly, you are bringing an application for a deferral of Mr. Karim's evidence to an undetermined date. That's your application, as I understand it. And the evidence leaders oppose that. And in their opposition, they say, we want him to come back on a specific date. So there is an opposition to your application.
Yes, it's a limited, that's the word they use in their correspondence of about the 23rd of July, if I'm not mistaken, where they say it's a limited opposition. And it's, if I can say this, the difference between my learned friend and myself is the mechanics of the postponement. What's not opposed is that a postponement is appropriate now. It's just subject to whether, as Commissioner Baloy correctly says, it's an open-ended date or it's a fixed date, and that's what I was saying to the chairperson as well. So it's not to say that it's no opposition in the sense that there's no disagreement. There is disagreement, but it's on the mechanics of the postponement rather than the narrower question that I was addressing, which is that the postponement being sought today, in principle, is unopposed between the Commission and ourselves.
But if it was being opposed in the wide sense, whatever that means, the consequence would have been that if it was opposed and opposed successfully, the consequence would have been that he comes and testifies today. He's not going to. He's not here. So the distinction is a technical decision, really, which makes no difference whatsoever. Fact of the matter is, you are seeking his evidence to be deferred. We are here today. You say indefinitely. They say, no, he's not getting the postponement that he wants. We want him to be given a date to come and appear. So I don't understand the technical differences, but at this point I wasn't engaging on the technicalities of indefinite, and I was simply saying, but this application is opposed. That's the position. Your application, as formulated by you, is being met with an opposition.
Yes, it's described as a limited opposition in paragraph 1.14 of the attorney's letter on behalf of the Commission of the 23rd of July. So that's where I was going to focus the bulk of my submissions, on the limited nature of the opposition rather than whether or not a postponement today ab initio is being opposed. I think that's where I'm directing myself, Commissioner Baloy.
Yes, all right. But you accept it is opposed?
Yes,
right?
yes,
Okay.
within the confines of what I've said. Yes, absolutely so.
Thank you.
I'm not, it's like in litigation where the parties might...
Please, I think.
Okay.
Please go ahead.
No,
please,
thank
please
you.
Continue.
I'm indebted. So by means of introduction, that's the first of the 12 points I wanted to make. The question in front of you is actually a narrower question about the mechanics of this postponement and what it ultimately looks like, whether it's to a fixed date or whether it's to an indefinite date. And what I will say to the Commission in that regard is two things. Number one, you have our submissions on paper justifying why it should be an indefinite date. But obviously the Commission, through the evidence leaders, have put up a series of considerations as to why it should be to a limited date. And practically speaking, that's something that, practically speaking, that's something the commissioners will apply their minds to and make a ruling on. And all I'm going to say is that the mechanics of that ruling will be whatever it is. I'm not going to focus my submissions on the harder element, if I can call it that, which is to say it should be to an absolute indefinite date. I'm going to focus on my submissions on the appropriateness of the postponement in the circumstances in light of the evidence that you have in front of you. So that's where that's what I'm going to focus on. Can I just say that, and the reason for that is because of the limited nature of this opposition, but I'm not going to repeat myself. Can I say on the second point, please, that there are two potential directives that we would ask the Commission to consider granting in respect of the proceedings today and the argument as it unfolds in front of you today and before my learned friend has an opportunity to address you. The first one is that I'm not sure what the status of these application papers will be or become once the Commission makes its decision on the postponement. But the request is that should any part of the record become public, that it is subject to the limitations already imposed by the Chair in the in-camera ruling. So that is that the record of papers itself must not reveal or identify the very things that the Chair has said we're not allowed to say in the oral argument, because that would effectively render that ruling pointless if the paper record reveals the very things that we aren't allowed to refer to in the oral hearing. I don't think that should be controversial. That's actually asking for a logical extension of the Chair's ruling as it applies to the papers. The second directive, and this might be the more controversial one, is I know my learned friend has given me advance notice that she intends to rely on certain CCTV camera footage. I don't know if that is still the case. But there are other pieces of information that the Commission has subsequently shared with us that may also need to be treated carefully. In particular, there is mobile data geolocation information which may or may not be projected. I don't know if my learned friend intends to project it on the screen when she makes her submissions. But if she does, the point that I would request the Commission to please consider and make a directive on is some of that information contains highly specific GPS coordinates. And the reason that when it is projected onto the Commission's screen, if the Commission intends on doing that, to prevent the publication of exact GPS coordinates is because it opens the threat that the GPS coordinates, when projected onto the screen, can be used to reverse engineer exact locations. Obviously, if the CCTV footage puts my client at a Durbanville mall, I can hardly complain about that. But I'm raising a concern in respect of the facility, for example, and geolocation data near the facility. I would also humbly request that in making such a directive, when my learned friend is going to refer to or reference the suburb that the facility is located in, that the name of the suburb is not mentioned explicitly, because it doesn't take a genius to run a Google search or a ChatGPT search to ask it what medical facilities are in the particular suburb, with the effect that it gets close to the very things that the chair has said should not be identified. So I don't know, practically speaking, when chair will make those directives or consider them, but I think even in just flighting the fact that those are the directives I'm asking for, I'm hoping my learned friend will approach it with some degree of sensitivity, even in the absence of a directive. That's not to say my learned friend mustn't say what she wants to say or use whatever footage she does. I'm just raising the concern about certain of the information which is not necessarily expressly covered by the in-camera ruling might nonetheless be utilized to undermine the very purpose of the in-camera ruling. And that's the second request that I make. Chair, I'm in your hands as to practically whether you want me to go on.
I think for now, yes, for now, please continue with your argument. I don't want to eat into your time. What we will do, we'll raise this issue before Ms. Hassim starts arguing.
I'm indebted.
Yes. I don't think there's an issue with the
first one.
With the first one, really, but we can't make rulings piecemeal. Yeah.
Yes, indeed.
Yes,
indeed,
yes,
indeed.
yes.
So that's point number 2.
Please continue.
Thank you, Chair. I'm indebted. Point number 3, now talking about the video footage. With all due respect, in light of the affidavits that have been exchanged between the respective parties, I'm going to respectfully submit that the video footage is unnecessary today. And more than being unnecessary, it's also not appropriate and does not serve a legitimate purpose. And there are 3 reasons why. The first one is, by and large, the allegations made by the Commission have now been admitted, answered to, and amplified by my client and the people deposing on his behalf. So the footage is not necessary because the footage is not needed to prove admitted facts. You don't need to lead the evidence to deal with admitted facts. That's point number 1 as to why it's inappropriate. Point number 2 is that the footage is an inappropriate form of evidence in light of the fact that, and you will know this because this is dealt with explicitly by my client's treating doctor, that things like video footage and geolocation footage or geolocation information and so on does not have clinical value.
Sorry, what noun did you use? It's inappropriate what? It's inappropriate? What did I After inappropriate, what's the noun you use?
Oh, inappropriate form
Okay.
of evidence.
Oh, all right, thank you.
Inappropriate form of evidence because ultimately what underlies the Commission's concern and the Commission's complaint regarding my client's postponement is a medical issue. And so this geodata information or CCTV footage or whatever it is, on its own, not being led through a clinician, and not being analyzed by a clinician or responded to by a clinician is inappropriate secondary evidence, which is being used to gainsay the medical opinion expressed about that exact approach.
Are you talking about Durbanville or?
Yes, Durbanville.
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 Can you please explain your point about it relating to what may have to be attended to by a medical practitioner?
Yes. May I just ask Ms. Matlingwane for some
Because
assistance?
let me tell you why I'm asking you this. I see it as objective material which says he was there.
Yes.
So I don't see the connection with what a medical practitioner might have to say on the issue.
May I respond?
Yes,
Give two
yes,
responses. The
yes,
first response is that it's also accepted that he was there. So it's unnecessary because it's an admitted fact between the parties. There's no need to lead the evidence. But the secondary line of reasoning, and this is where I need Ms. Matlingwane's assistance, but she'll hear me in response to you, Commissioner. I'll give you the reference after the fact, is this. The medical practitioner says that the Commission relies on a bunch of evidence, such as CCTV footage, Apple Pay data regarding payment accounts, movement data gleaned through geolocation data. And the position of the clinician, for reasons that you know which are recorded on the papers, is all that demonstrates is movement of some kind, but that the movement of some kind, the fact of the existence of the movement of some kind, is of no value in determining the clinical issue as to why the client cannot attend or attend the Commission to give evidence. So the point as to inappropriate is that it doesn't deal squarely, with all due respect, with that clinical issue, and particularly in circumstances where the clinician has raised doubt about why it's being used in the manner in it's being used.
I get you on your first point, which is why flight that footage if there is no dispute about his location on the day and at the time. I get your point. I'm not sure that, one, you need the second point, and two, I am not subject to whatever else you may say. I'm not convinced by your second point. But please continue. But I stress that you don't, in the face of your first point, I'm not altogether sure that you need the second point. On this issue, it's a very weak point.